Hello. First of all, let me introduce myself. My name is Luis Fernando Rodrigues Pinto Jr. I am the Special Secretary for Electoral Affairs at the Office of the Attorney General of Justice in São Paulo State, Brazil. I belong to an institution whose profile is outlined in Article 127 of the Federal Constitution of Brazil of 1988. And where the system of entry into the career for this job takes place through public examinations and titles. I personally joined it in November 1989 after a one-year competition with 5 phases, 3 written and 2 oral, and the position is for life. I was invited for the second time for this speech as part of the celebration of the World Constitution Day on August 1st, 2022. And I wish to say thank you to my friend Professor Nicholas Merlone and also to Jim Scherrer, coordinator of the World Constitution Day in USA, for the invitation. Last year, we talked about the profile of the public ministry in the Constitution of Brazil and the defense of democratic order and citizenship. This speech is on my page at YouTube. Now, we are going to learn a little about the electoral system in Brazil. So, welcome to this brief talk. The Federal Constitution of Brazil of 1988 has in its preamble the following sentence: "We, representatives of the Brazilian people, gathered in a national constituent assembly to establish a democratic state destined to ensure the exercise of social and individual rights, freedom, security, well-being, development, equality, and justice as values principles of a fraternal, pluralistic, and unprejudiced society, founded on social harmony and committed in the internal and international order to the peaceful solution of controversies. We enacted under the protection of God the following Constitution of the Federative Republic of Brazil." And right in the first article, it deals with the fundamental principles as follows. The Federative Republic of Brazil, formed by the indissoluble union of states and municipalities and the federal district, constitutes a democratic state of law and is based on sovereignty, citizenship, the dignity of the human person, the social values of work and free enterprise, and political pluralism. And all power emanates from the people, who exercise it through elected representatives or directly under the terms of the Constitution. Therefore, right from the beginning, we realize that Brazil is a democracy and that the way of choosing the representatives of the people happens through elections. It's through popular vote that the population can participate directly in the country's political process. According to the third article of our federal constitution, the fundamental objectives of the Federative Republic of Brazil are to build a free, fair, and solidary society, guarantee national development, eradicate poverty and marginalization, and reduce social and regional inequalities, promote the good of all, without prejudice of origin, race, sex, color, age, and any other form of discrimination. This means that the constituent legislator was concerned with making the Brazilian nation a free and fair place to live in society. And in the same way, it made clear how the country should relate to other nations, bringing the following comment: Federative Republic of Brazil is governed in its international relations by the following principles: national independence, prevalence of human rights, self-determination of peoples, non-intervention, equality between states, defense of peace, peaceful resolution of conflicts, repudiation of terrorism and racism, cooperation between peoples for the progress of humanity, granting of political asylum. It is clear the pacifist scope and principles of human rights that belong to the Brazilian nation. Well, to understand the exercise of the attribution that the Constitution presents to citizens for the full exercise of democracy, it is necessary to define what political rights are. Also called citizenship rights, political rights form the set of prerogatives attributed to a person which allows them to have effective participation and influence in government activities through voting, exercising public office, or the use of other constitutional and legal instruments. To be in possession of political rights means to be able to enlist, register to vote, to qualify for a candidacy for elective office, or for an appointment to certain non-elective public positions. It also means having the right to vote in elections, plebiscites, and referendums, to present bills through popular initiative, and to propose popular actions. Popular actions is a constitutional action made available to any citizen that seeks to invalidate an act harmful to public property or to an entity in which the state participates, to administrative morality, to the environment, and to historical and cultural heritage, and to be decided by a judge. Anyone who does not enjoy political rights cannot join a political party or assume any public office, even non-elective ones. The chapter 4 of the Federal Constitution, in Articles 14 to 16 and its paragraphs, regulates the political rights. It consists of popular sovereignty will be exercised by universal suffrage and by direct and secret vote, with equal value for all and under the terms of the law through plebiscite, referendum, popular initiative. And electoral enlistment and voting are mandatory for those over 18 years of age and optional for the illiterate, those over 70 years of age, those over 16 under 18 years of age. So, in Brazil, voting is secret and mandatory for people over 18 years old, being optional for people over 70, illiterates, and those between 16 and 18 years old. Foreigners, and during the period of compulsory military service, conscripts, which are Brazilians called up for compulsory military service in the armed forces, cannot register as voters. This concept also extends to doctors, dentists, pharmacists, and veterinarians who perform compulsory military service. Let's talk now about who can be a candidate. Eligibility conditions in the form of the law are Brazilian nationality, the full exercise of political rights, electoral enlistment, the electoral domicile in the district, party affiliation, the minimum age of 35 years for president and vice president of the republic and senator, 30 years for governor and vice governor of the state and the federal district, 21 years for federal deputy, state or district deputy, mayor, vice mayor, and justice of peace, 8 years for aldermen. The unlisted and illiterate are ineligible. Here, we have to remember that according to the second article of the Constitution, we have three powers: the legislative, executive, and judiciary, and they are independent and harmonious. The well-known tripartition of powers. In Brazil, we have the federal central power, which is the union, and also the states and municipalities. All have their respective legislative and executive powers. The Union, with two houses in the Legislative Chamber of Deputies and Senators, and the President of the Republic as head of the executive power. The states, with a single house in the Legislative, the Chamber of Deputies, and the Governor as head of the executive, and the municipalities, with the Chamber of Aldermen as the legislative power, and the mayor as chief of the executive. These powers, legislative and executive, are made up of representatives elected by the people. On the other hand, the judiciary may be federal or state. The state judges act in the municipalities. The members of judiciary are not elected, but are part of a state career in which entry is made through a public contest of tests and titles, and cannot be dismissed except through a process with the right to ample defense. It's a job for life. The President of the Republic, the governors of the state, and the federal district, the mayors, and whoever have succeeded or replaced them during the course of their mandates may be re-elected for a single subsequent term. Currently, the term of office is 4 years, and a single re-election can take place. to run for other positions, the President of the Republic, the Governor of the State and Federal District, and the mayors must resign for their respective mandates up to 6 months before the election. The spouse and consanguineous or similar relatives up to the second degree or by adoption of the President of the Republic, the Governor of a State, of territory, Federal District, the mayor, or whoever else he placed them within the 6 months prior to the election, cannot be elected in the same territory of jurisdiction as the holder, unless they already hold an elected mandate and are candidates for re-election. The enlisted soldier is eligible, provided that, if he or she has less than 10 years of service, must leave the activity. If has more than 10 years of service, will be added by the higher authority, and if elected, will automatically pass upon graduation to inactivity. The Constitution also determines that a complementary law establishes other cases of ineligibility, as well as deadlines for their cessation, to protect administrative improbity, morality, or exercising a mandate considered to be the candidate's previous life, and the normality and legitimacy of elections against the influence of economic power or the abuse of the exercise of a function, position, or employment in direct or indirect administration. If a popular consultation has to be carried out on a local topic, it must be carried out concomitantly with the municipal elections, and provided that they are approved by the municipal councils and sent to the electoral court up to 90 days before the date of the elections, observing the relative operational limits to the number of questions. Later, we will see what this electoral justice is all about. Political rights cannot be revoked, and their loss or suspension only occurs in the following cases: cancellation of naturalization by a final and unappealable court decision, absolute civil incapacity, criminal conviction that has become final and unappealable while its effects last, refusal to comply with the obligation imposed or on all or alternative provision under the terms of Article 50, administrative improbity. And if any law changes the electoral process, it may enter in force on the date of its publication, but it does not apply to the election that takes place within 1 year of the date of its validity. Let's talk about the electoral system. There are two systems within the Brazilian electoral system: the majority system and the proportional system. The majority system demands that the elected candidate achieve a simple or absolute majority in the election. The proportional system demands that the candidate and his party meet the criterion known as the electoral quotient. The majority system determines that to be elected, the candidate or candidates, in the case of senator election, must obtain an absolute majority of votes or a simple majority. Achieving an absolute majority means that the candidate has obtained more than 50% of the total valid votes. Remember that to determine the result of an election, null or blank votes and absent voters are discarded from the count, and only the electorate that actually voted for a candidate is considered. Thus, excluding null and blank votes and absent voters, we reach the real valid votes. The candidate who obtains more than 50% of this vote is elected. Majority systems are mainly used in elections for executive positions. In the Brazilian case, for the election of the President of the Republic, the governors of the states, and the mayors of municipalities with more than 200,000 inhabitants. An absolute majority of votes is required, and if this is not achieved, a second round takes place, just a little days after. This is because if in the first round none of the candidates obtain the minimum number of votes to be elected, more than 50%, a second round is established with the two most voted candidates in the first round. Mayors of municipalities with less than 200,000 inhabitants are elected by the simple majority method. In the case of a simple majority, it's not necessary for the candidate to obtain an absolute majority of votes. Thus, the candidates with the largest numbers of votes are elected, even if the percentage is less than 50%. The proportional system can occur in two ways: open list or closed list. The open list is the one used in Brazil, and it is the one in which voters directly choose their candidates. On the other hand, the closed list is the one in which the voters vote only for the political party, and this party is responsible for selecting through a list vote the candidates who will effectively occupy the elected mandates. It's not our case. The proportional system is used in the election for legislative position, with the exception of the position of senator. That is, election of councillors, state deputies, district deputies, and federal deputies. But although Brazil uses the open list, the candidates with the most votes are not necessarily elected. The most voted from the parties that won legislative seats are elected. The voter votes for the candidate, but the vote also counts for the respective party. In the system, parties win legislative seats through the number of votes they receive. What determines the number of legislative seats a party received is whether or not it has won the minimum number of votes established by the electoral quotient. Once this accounting is done, the parties receive the number of seats proportional to their advantage. Thus, if the electoral quotient is 10,000 votes and a specific party wins 70,000 votes, this means that it will have 7 legislative seats. In this way, 7 candidates from that party, the 7 most voted, will be elected for the legislative seat they are running for. If a party does not reach the amount established by the electoral quotient, it will not win any seats. Through the system, the candidates with the most votes are not always elected, since the distribution of seats take place according to the criterion established by the electoral quotient. The quotient is established by the total number of valid votes divided by the number of seats available. It's important to mention that candidates in the race must obtain at least 10% of the total votes in relation to the electoral quotient. Thus, if the electoral quotient is 10,000 votes, candidates must obtain at least 1,000 votes to be able to fill their party's legislative vacancies. If a party does not have enough candidates to fill the vacancies, Brazilian electoral legislation determines that that party must lose the unfilled vacancies, and they are redistributed to the other parties and candidates in the dispute. Well, let's talk about political parties. Political parties are organizations of forces of a community in the form of a political body with the aim of disputing power in society. It has an associated character, a function of dispute for the political power of a society, and the objective of bringing together different subjects around similar ideas in the search for a combined political action. According to Article 17 of the Brazilian Federal Constitution, the creation, merger, incorporation, and extinction of political parties is free, safeguarding national sovereignty, the democratic regime, multi-party system, the fundamental rights of the human person, and observing the following precepts: national character, prohibition of receiving financial resources from a foreign entity or government or of a subordination to them, accountability to the electoral court, parliamentary functioning in accordance with the law. Political parties, after acquiring legal personality in the form of civil law, will register their statutes with the Superior Electoral Court. Further on, as already mentioned, we will see in a few minutes what the electoral justice is and what the Superior Electoral Court is. Political parties are guaranteed autonomy to define their internal structure and establish rules on the choice, formation, and duration of their permanent and provisional bodies and on their organization and functioning, and to adopt the criteria for choosing and governing their coalitions in majority elections, its celebration in proportional elections, with no obligation to link candidacies at the national, state, district, or municipal level, and its statutes must establish rules of discipline and party loyalty. In Brazil, there is a provision for free electoral advertising on radio and television, as well as government budget resources that are passed on to parties. This is called the party fund. And the Constitution requires some criteria for parties to have access to such forecasts. In particular, effective representation in parliament, such as, for example, having elected at least 15 federal deputies distributed in at least one-third of the federation units. Other interesting prediction says that federal deputies, state deputies, district deputies, and councillors who leave the party for which they were elected will lose their mandate, except in case of party consent or other hypotheses of just cause established by law, not computed in any case party migration for the purpose of distributing party funds or other public funds and free access to radio and television. Political parties must apply at least 5% of the resources of the party fund in the creation and maintenance of programs for the promotion and dissemination of women's political participation according to intra-party interests. The amount of the special fund for campaign financing and the portion of the party fund destined for electoral campaigns, as well as the free advertising time on radio and television to be distributed by the parties to the respective candidates must be at least 30% proportional to the number of candidates, and the distribution must be carried out according to criteria defined by the respective governing bodies and by the statutory rules, considering the autonomy and the partisan interests. There are clauses that make clear that the mandate belongs to the party and not to the candidate, and that aim to protect the participation of women in political life within the parties. Well, let's go ahead and try to understand what electoral justice is and how elections happen in Brazil. Unlike what happens in other countries, elections in Brazil are held, controlled, and organized by the judiciary power. Exactly because its members are not elected and cannot integrate political parties, as well as they cannot run in elections, the judges, who are for life in their positions, are absolutely exempt to act and take care that everything happens in the best way in the elections, always ensuring law enforcement and balance in power relations. So, there is a specific branch of the judiciary for this activity. His name is Electoral Justice. Its members are not always the same, but alternate for periods in order to maintain an oxygenation of decisions. That means updated according to the context and demands of the society. There is a mix between career judges and private lawyers who serve for a limited time. Once the period is over, they return to their daily activities. We can say then that the electoral justice is an organism of specialized jurisdiction that integrates the judiciary power and takes care of the organization of the electoral process, electoral registration, voting, counting of votes, diplomacy of the elected, etc., etc. It works to guarantee respect for popular sovereignty and citizenship. Let's see how the federal constitution outlined the profile. But before that, it's necessary to remember that in Brazil, we have divisions of the judiciary power in federal justice and state justice, with the singular judges and the courts of appeal, called courts of justice, where the magistrates are called, the word is in Portuguese, desembargadores. That means the judges in court of appeal. The two superior courts, the last instance of appeal, are the Superior Court of Justice, we call STJ, and the Federal Supreme Court, STF. This one being equivalent to the North American Supreme Court, responsible for guarding and interpreting the federal constitution. Now let's understand the organization of the electoral Brazilian system of justice. According to Article 118 of the Constitution, are federal justice bodies, the Superior Electoral Court, acronym TSE, the Regional Electoral Courts, TRE, the Electoral Judges, the Electoral Boards. The Superior Electoral Court is composed of at least 7 members, 3 judges from among the justices of the Federal Supreme Court, which currently has 11 members. The choice is made through election by the secret vote of its own members. 2 judges from among the justices of the Superior Court of Justice, which has now 33 members. The choice is also made through election by the secret vote of its own members. 2 judges out of 6 lawyers of notable legal knowledge and moral standing, indicated by the Federal Supreme Court and appointed by the President of the Republic. The Superior Electoral Court will elect its president and vice president from among the justices of the Supreme Federal Court, and the electoral corregidor, that's something like an internal inspector, from among the justices of the Superior Court of Justice. According to the Constitution, there will be a regional electoral court in the capital of each state and in the federal district. The composition of this regional electoral court is 2 judges from among the judges of the Court of Justice from the respective state, chosen by election by secret vote of its own members. 2 judges from among the singular judges chosen by the Court of Justice from the respective state. 1 judge of the Federal Regional Court, that is the Federal Court of Appeal, based in the state capital or the federal district, or in absence of a federal judge chosen in any case by the respective Federal Regional Court. And 2 judges from among 6 lawyers of notable legal knowledge and moral standing, appointed by the Court of Justice of the respective state and appointed by the President of the Republic. The Regional Electoral Court will elect its president and vice president from among the desembargadores, as I said, the name given to the judges who older in their careers are part of the Court of Appeal of the states. The judges of the electoral courts, except for justified reasons, shall serve for a minimum of 2 years, and never for more than 2 consecutive biennia, with the substitutes being chosen on the same occasion and by the same process, in equal numbers for each category. The members of the courts, the judges of law, and the members of the electoral boards, in the exercise of their functions and in what is applicable to them, will enjoy full guarantees and will be irremovable. There is a complementary law that governs the organization and the competence of the courts, judges, and electoral boards. The electoral boards are those in each city in which voters must register and be bound by their vote. The citizen will be registered in one electoral board that is close to his or her address. On the election day, usually schools are reserved as a physical place to put the ballot box according to the number and region of the respective electoral board. The ballot boxes are all electronic and very well protected, among other factors because they are not linked to the internet. They are really safe, despite some statements to the contrary. Electoral judges are judges of first degree of jurisdiction who are members of the state court and the federal district. Article 32 of the Electoral Code, and here I want to remind you that in addition to the provisions of the federal constitution, we have specific legislation for the subject, among them an electoral code valid through the national territory as the Brazilian legal system works. The electoral boards are composed of 1 judge of law, who will be the president of the electoral board, and 2 or 4 citizens of notorious reputation. Let's see the competencies. Competencies of the electoral justice are listed in law number 4737 of July 15, 1965. That is the Electoral Code, which is partly approved as a complementary law by our federal constitution in 1988. Some of the electoral justice main powers are to process and initially judge the registration and cancellation of registration of political parties, their national directories, and candidates for the presidency and vice president of the Republic. Judge special appeals and ordinary appeals filed against decisions of regional courts, approve the division of states into electoral zones or the creation of new zones, request the federal force necessary to comply with the law, its own decisions or the decisions of the regional courts that requested it, and to guarantee voting and counting, and finally, take any other measures it deems convenient for the implementation of electoral legislation. Some of the duties of electoral judges are prosecute and judge electoral, electoral crimes, and common crimes, except for what is originally the competence of the Superior Electoral Court and regional electoral courts. Issue electoral certificates and grant voter transfer, and take all measures within its power to prevent illegal acts in the elections. The electoral boards are responsible for keeping the registrations of the citizen voters and for resolving challenges and other incidents verified during the counting work, as well as issuing diplomas to candidates elected to municipal positions. It's interesting to observe that the electoral justice performs, in addition to jurisdictional functions proper to the judiciary power, other administrative functions, as well as normative and advisory functions. We can call them rule adjudication, rule application, and rule marking. Regarding the administrative function, the electoral judge administers the entire electoral process, and examples of the exercise of administrative functions are electoral registration, transfer of electoral domicile, and measures to prevent the practice of irregular electoral propaganda. Regarding the jurisdictional function, the judge will act in the solution of conflicts whenever it is judicially provoked to apply the law, as in the common justice. For example, situations of filing an electoral judicial investigation action, an action to challenge an elective mandate, an action to challenge the registration of a candidacy, and in representations for irregular electoral propaganda. Regarding the normative function described in Article 1st and paragraph and Article 23 of the Electoral Code, there is permission for, through resolutions, to issue instructions for the execution of electoral laws, including the Electoral Code. The content inserted in these norms is intended to regulate the matters within the competence of the collegiate body that instituted them, creating general and abstract situations. As an example, the instructions created to assist the execution of laws in the year of the elections, as a discipline on the collection and the expenditure of resources by political parties, candidates, and financial committees, and also on the accountability in the elections. Finally, the advisory function allows the pronouncement of specialized justice without necessarily having the character of a judicial decision itself on issues that are presented in theses, that is, of abstract and impersonal situations. As a rule, the judiciary power is not a consultation body, but in the case of the electoral court, there is this peculiar characteristic that guarantees the possibility of being consulted in order to express itself on a certain understanding, which helps to avoid future demands and conflicts. Thus, in this topic, we can conclude by saying that the electoral justice is responsible for receiving the application for registration of candidacies, for distribution of electoral propaganda time, for the accountability of political parties and candidates, for the preparatory acts for the vote, for the organization on election day, and for the aggregation, proclamation, and diploma of those elected. As a result of the work led by the Superior Electoral Court, sorry, but in Portuguese, the word is eleitoral. That's why sometimes the accent changes. So as a result of the work led by the Superior Electoral Court, Brazil has sustained high scores in the integrity index of its election, according to the ranking of the Electoral Integrity Project developed by the universities of Sydney, Australia, and Harvard in the United States. In 2015, for example, Brazil received a score of 74.1 on a scale from 0 to 100 and ranked 27th in the ranking of countries evaluated, ahead of nations such as Italy, Japan, and even the United States. The grade given to the Brazilian process was higher than the average for the countries of the Americas, which received 69 points, and was even higher than the world average, which was 64 points. Well, finally, as a member of the public ministry, I cannot fail to speak a little about the institution's role. It's my institution. As a defender of the democratic regime according to the federal constitution, the public ministry has the legitimacy to intervene in the electoral process, acting at all stages: voter registration, party conventions, registration of candidacies, campaigns, electoral propaganda, voting, and diplomacy of the elected. This segment is called Electoral Public Ministry and does not have its own structure. It is composed of members of the Federal Public Ministry and the State's Public Ministry. The Attorney General of the Republic performs the function of Electoral Attorney General before the Superior Electoral Court and appoints members to also act in the Superior Electoral Court. They called sub-attorneys. And in the regional electoral courts, regional electoral attorneys of justice who head the electoral public ministry in the states. Electoral prosecutors or attorneys of justice are members of the state public ministry who perform their duties by delegation from the federal sector. The members serve for a time as the judges and return to their original positions at the end of the term of service, remembering that the job at the original position is also for life. The intervention of the electoral public ministry, I mean the prosecutors and attorneys of justice, also occurs in all instances of the judiciary power at any time, with or without election, and can be as a part investigating crimes or civil offenses and proposing actions, for example, or as a fiscal of the law, offering opinions on ongoing cases, or provoking judges to exercise their police power. In municipal elections, which take place every 4 years alternately with the others general calls, the role of state electoral prosecutors is full. In general elections, those for state and federal positions, the role of members at states takes place in the investigation of electoral crimes, while members of the federal public ministry take care of all the other issues. The public ministry members play a great role in any of the phases of the electoral procedures, especially in the actions of judicial electoral investigation, action to challenge an elective mandate, appeals against the diplomacy of candidates, challenges to the request for transfer of electoral domicile, copy of electoral certificates, or challenges to the registration of candidacies. They must also receive all complaints made by society about undue facts practiced in the electoral scope, proceeding with the respective investigation, bringing the action before the electoral court, if applicable, appealing until the final decision. Also, they must keep an eye over the political parties about the gender quotas and dedicate itself to the task of inspecting and demanding from public and private authorities compliance with the norms for combating political violence against women. It's really an important task. Well, to conclude, I can say that it's a fact that the electoral system may seem a little complex, but its peculiarities make it an exponent in the scenario of a democratic country. everything is designed so that the popular will can be exercised through voting and that candidates have the opportunity to present their ideas on how they perceive life in society and how they intend to carry out their projects in the pursuit of building a better nation. Without the vote, there is no democracy, and without democracy, there is no freedom. A fundamental principle of human beings and of our existence on the planet, and which must be defended at all costs, as well as respect for the rules established for community life and the performance of the institutions as drawn in the federal constitution text for such scope. My intention was to outline a little of the functioning of the Brazilian electoral system to bring to the attention of those who are not integrated with such a structure, either because they do not work in the legal area or because they do not live in Brazil, and thus indicate that our democracy has everything to follow the path of success, despite the natural obstacles that we must always overcome with dedication and hard work. I would like to thank you that is watching, as this is a humble way to show other people how the electoral system works here in my country, and those that invited me to have this opportunity to publicize such an important topic. My final words: be in peace, and let us all continue to fight for the defense of the freedoms of individuals and society, and for the preservation of the text of the constitutions throughout the world. Thank you very much.